Hey y'all, welcome back to the channel, Legalese with Avi B, where I'm here to help you navigate the law with ease. So y'all, it has been a minute since I've seen y'all, talk to y'all, and I just want to say 2020 was rough for me. It was a long, challenging year of growth, but we have made it to the new year and I am thankful to be in 2021. I'm promising to be more consistent with my posting this year as we dive into some interesting topics. Feel free to continue to let me know what you want to hear about, what you want to talk about in the legal field, or specific cases, anything I'm open to diving into in this year. So today, we are going to be talking about trials, specifically some of my favorite trials, my first trial, and just what they entail. So as you all probably know, most cases resolve before they even get to the trial phase. So in the criminal world, the prosecutor or the district attorney has most of the power in the courtroom to decide the flow of a case, especially in North Carolina where the prosecutors control the flow of court and the schedule of the court. And so the prosecutor and the defense attorney usually can come to some type of resolution prior to going to trial. And it's even been said that if cases actually went to trial, we probably would jam the court system up, especially with COVID-19 right now and us already being behind schedule. If we took more cases to trial, the court system would not even be able to handle the amount of cases that there are. You have a good lawyer on your team if you have one that is not always pressing you to take a plea and is willing to fight it out in a trial on your behalf. There's a lot of skill and a lot of technique that goes into a trial. So let's just break down the components of a trial just in the very general, basic sense. What happens at a trial? And so you have the prosecutor and the defense attorneys are the two competing parties here, right? The prosecutor has the burden of proof. They have the burden to establish their case. As most of y'all have probably seen on TV, they have the burden of proof beyond a reasonable doubt to either the judge, if there's a bench trial, or to the jury, if it's a jury trial, to prove their case. So the law sets out specific elements for each crime. Each crime, there's a number of elements that have to be proven. And if the prosecutor cannot hit each and every one of those elements with evidence, then more than likely they won't be able to prove their case. Now we know that there are some other things that come in, such as biases and other factors that come in our criminal justice system, despite whether or not the prosecutor was able to meet their burden. But I ain't gonna get into that today. So the district attorney or the prosecutor, DA, assistant DA, those terms are pretty much interchangeable. The district attorney is the elected prosecutor in the office, and then the assistant district attorneys are those who work under their leadership. The defense really has to just poke holes in the state's case and come in and show that there are certain things that, to bring about questions in the state's case, right? Because we don't have to prove anything. It's just our job to poke holes in their case to say that they did not show, that they did not meet their burden, and they did not have the evidence to support, they didn't have the facts to support the crime that the defendant has been accused of. And I'm using the word defendant for the sake of this video in terms of speaking of a trial, but y'all know how I feel. I don't like to refer to people in terms of labels. That's not my thing. And so for the sake of this video and explaining each party in a trial, I'm going to use it today. So those are the roles that we have. So when a case starts, in a lot of times in district court, so we have different levels of court. We have district court and we have superior court. In district court, a lot of times they skip the opening statement phase, but if you've seen on television shows, a lot of the cases where they are in superior court, the higher level of court before a jury, there's this opening statement where they come in and they give you a brief overview of their case, where they get to tell the story, right? Where they get to hook you in. That's the opening statement. And then the prosecutor gets to start, right? The case, they get to present what's called their case in chief, where they get to call their witnesses, put on evidence, but the rules of evidence govern a trial. And so the prosecutor puts on their witness and the defense attorney gets to ask them questions and do so in a certain way. I won't go into all the technical skills of a trial. Each each witness that goes up gets to be asked questions by the district attorney and the defense attorney. There's, the back and forth phase. And then the defense attorney gets to go. And the defense attorney can choose whether or not they want to put on evidence. Now, again, frequently they don't, because they don't have a burden of proof, at least in district court anyways. In superior court, both sides are usually presenting evidence. But if the defense attorney chooses to put on evidence, then the process is the same. They get to ask questions, and then the state gets to come in and do cross-examination of their witness and ask them questions. As y'all know, it can be very heated sometimes when you have a witness up there and they are combating you, and there's that whole little back and forth phase. But trials can be very fun for lawyers. I know, me personally, I see it as if I am on stage and I am putting on a show. So I can get a little bit theatrical sometimes, not too much to the point where it's not believable, but I just put on this character in my mind where I'm just this boss lawyer, and I'm putting on this show because I want you to feel what I'm saying. I want you to side with my client, the defendant in the case. And so I want you to hear me and feel me. And so I'm gonna, put on a show for you. And I'm gonna lure you in and entice you with the things that I'm saying, but not in a way, of course, that is, in violation of any rules or any ethical considerations that lawyers have to follow. So that is the back and forth phase, where you're putting on evidence, where both sides are presenting their case in chief. And then usually there's some type of motions that either have already been made or will be made. Those things are kind of behind the scenes sometimes, where the jury gets walked out, motions are being made. There's a bunch of other components, but these are the very basic parts, the very bare bones of a trial. And then you get to the closing argument, where you get to nail it in. You get to really just put it on, say what they heard and why the state didn't meet their case. Or, if you are the prosecutor in the case, say what evidence was heard and why the jury should convict the defendant, or why the judge should find the person guilty. That's where you're really just hitting it in for the final blow. And so those are just some general components of a trial. As you can tell, I like trials. I think that they're fun, and I wish I had more, but COVID-19 has really just come and tore us all up. The courts have been closed for a significant period of time. We're now on another 30-day closure, which will be up next week. Thank God. Now I'm going to jump into what my very first trial was, because some people have asked me what that experience was like and if I get nervous, or if I was nervous. So my very first trial took place while I was an intern in law school. I was interning at a public defense office, and I think I was a 2L, a second year law student. And let me just tell y'all, my very first trial involved a stripper, some wands, and my client, who was claiming that he had not stolen anybody's wands. Just to give you a little precursor. And so just, for background's sake, I was extremely nervous. So like I said, I was at the public defender's office. I had been there for a couple weeks. My supervising attorney was out this day, and I got paired with another supervising attorney who was very risk-taking. He loved trials. He would prepare for them like on the whim and win them. And so that day, I was working under his supervision, and he comes into the back office and was like, "All right, you're up for a trial." And I was like, "I'm sorry, excuse me, sir?" He was like, you're up next. And I was like, wait, I haven't even seen the file, have not met the client yet. He said, "So go out there, grab the client, have a client interview. It's low stakes." This is no anything to public defenders at all, because they are some of the best lawyers I know, and I don't want y'all to use this story and glaze it over in terms of what public defenders do. But this was a very low stakes trial. My client it was very clear that he was not guilty, and my supervising attorney thought that it was an easy case for me to win, more than likely. Either way, my heart was beating out of my chest. I had not even taken evidence yet, so I didn't know all of the rules and all of the objections and all of the things. But let's just say I won that case and my client was found not guilty. So here's just a brief summary without violating any of our ethical rules about our case. So My client had gone to the strip club and had met this stripper that he was flirting with. She invited him back home. They had a little razzle dazzle. Some of her ones went missing. She went down to the police station, pressed charges, and my client was ultimately charged with larceny for stealing some of her ones. Now, when I couldn't believe that this case was even in court. When the state put on their witness, this person who was accusing my client, y'all, in the moment, like, I'm jotting down questions like on the fly. In the moment, like, it all just came to me. Like, I'm lighting into her on cross-examination. We were able to discover that he was not the only person who had come over that night, that she kept her ones in multiple places, that I asked her, did she hear him steal any ones? Did she see him steal any ones? She claims that the ones went missing when she went to the bathroom. Now we discovered, I asked where the ones were. They were having a little party that night. So the ones were all over her house, all over the bed, all over the floor. Y'all, it was a whole situation. And the whole time I'm sitting here thinking, like, this is really how we utilize the court's resources. She couldn't tell us how many ones had gone missing. She didn't know how many ones she had. She had made a lot of money that night, and they were just, you know, throwing them all over the place. Talk about a crazy first trial. But I lit into her on cross-examination, and I got her to confess to all of these things, that she didn't see him take the money, that she just had an inkling that it was him, even though there were other people who were there that night, that she didn't hear him wrestling in her drawers. She didn't hear. All of this stuff comes out on cross-examination, and I didn't even have to present any evidence. My client wanted to get on the stand to tell the judge that he did not do it. And this was a bench trial, so I was not in front of a jury. It was district court. Like I said, it was low stakes. He had no criminal record, so his likelihood of going to prison or going to jail was very low. You know, very low stakes thing. But still, like, for me, I felt like Olivia Pope. Like, I'm ready to go to war to make sure that my client does not get convicted because he did not steal this lady's ones. So ultimately, I decided that it was not a good idea to let him take the stand, and I got him to agree with me that if he just let it play out, that the judge would find him not guilty, and it would not be necessary for him to get up there and be exposed to anything that the state might ask him, all those things. So that case resolved in probably, honestly, like 20 minutes, y'all. It was a very short case, and that judge banged that gavel down and said not guilty, and I strutted my stuff out of that courtroom, and I knew right then and there that I loved trials. I loved court. Even something so simple. Now, this is not to, you know, make light of court at all, because court can be a very stressing, nerve-wracking thing for a lot of attorneys. But that trial was like, oh yeah, this is good. This is where I'm supposed to be. This is what I'm supposed to be doing. So that was my very first trial while I was in law school. I think that more people should go to trial instead of just pleading out, because it would really show district attorneys and police officers that they can't just be stacking charges and just charging folks with stuff that they cannot prove. I think that people would be a lot... Oh, in North Carolina, I think it was said that in 2018, almost 90% of cases were resolved through pleas. And a lot of times it was people who either the state probably could not have met their burden at a trial, or, you know, the person was completely not guilty, but because they were tired of being dragged back and forth into the criminal justice system, because it's a slow moving process, they just said, listen, I'll do whatever it takes to get me out of here, and they pled guilty. And that's not justice, and we don't want to be perpetuating that. But I've been talking long enough. That is my very abbreviated version of trials. I have some interesting trials that are hopefully set. We don't know what's going to happen with COVID, but I have some interesting trials, and I'm excited to potentially get back into court. Maybe, I don't know, Joe Biden might come and shut us all down. But either way, I hope that you all have had a safe and happy holidays. And I hope that 2021 is taking off in a good way for you, despite what is happening in our government right now. All right, y'all. As usual, be sure to like and subscribe, share, and comment. And it's been real. I will see y'all soon. All right.